Just doing a mic check. Thumbs up. Karn, thank you, Karn. Just checking in since it is 9, but I can't see the whole room. I can just see Russ and Karn. Cami, I think you guys are muted. Can you unmute so I can see the room?
Yeah, the room is pretty empty.
Pretty empty. Okay, cool. That's fine.
Yeah.
Yeah.
I'm the only board member here.
Yeah.
All right. Well, I guess that's why you're the only one I can see.
Yeah.
Try to change my view so I can see more of you. Okay.
We're just missing Bill. Okay. Madam Chair. Yeah.
Yes.
It looks like all the board members that had confirmed that they were going to be here are here today. Bill was a maybe and Jill was a no. So I think we're ready to go whenever you are.
Okay. I will get going. Cami, you're good if I go? I'm going to use Karn as my
Yeah.
Yes. Okay. Great. Well, welcome everyone to the May 20th, 2026 Mine Land Reclamation Board meeting. I'm Nell Wareham as your chair today. Apologize for being virtual. I need to host another meeting up in Frisco this afternoon, and I didn't want to cut it too close with our friends on I-70. You never know. So with that being said, if you can't hear me, if something's not working, please just speak up so that everyone has the same opportunities. We'll do a quick roll call. Let's see. I believe we have Stiglmeyer in the room.
Yes, I am here, present.
Thank you. And Doug Oren is online.
Yes, here.
As is Wendy Padilla.
Here.
And so I have 4 members of the board. Is that correct?
I'm also here.
I can't see who that
Allison
is.
Tarrant.
Oh, thank you. Hi. You were not on the last one, so you weren't in the minutes when I was going over my last names. Thank you. Gotcha. Okay. With that, we are going to do the approval of the April 2026 summary of minutes. Do I have a motion?
I'll make a motion to approve.
Stiglmeyer, any second?
I'll second.
Oren, any comments? All those in favor, please signify by saying aye.
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 Those opposed, same sign. Ms. Tarrant, you can hear us?
I can, yes.
Okay, you just didn't come off mute. Great. And the next one is the approval of continuances and withdrawals. To the best of my knowledge, I can see that number 5, which was an enforcement hearing, has been withdrawn. Is that correct?
That is correct.
Any other details? Okay. Motion to approve the continuances and withdrawals, noting that item number 5, M-2002-109 has been withdrawn.
So moved.
Tarrant,
Second.
Stiglmeyer, comments? All those in favor, please signify by saying aye.
Aye.
Okay. Let's move on to the Executive Director's Report. Ms. Padilla, take it away.
Thank you. A legislative update. The legislature adjourned on Wednesday last week, and overall, it was a very difficult budget year, which saw legislators having to make some tough budget decisions. But we have some good news on several of our legislative priorities. House Bill 26-1008, which is the Outdoor Opportunities Act, passed, and this strengthens Colorado Parks and Wildlife's capacity to provide outdoor recreation while balancing that with conservation, wildlife habitat, working lands, and private property rights. And it will improve collaboration, planning, and management processes around the state and advance Colorado's outdoor strategy goals. The Water Projects Bill passed and received relatively easy bipartisan support, and it includes $380,000 to continue satellite snowpack monitoring, $2.5 million to continue critical weather forecasting efforts, and $5 million for watershed restoration and flood mitigation projects. There's quite a bit in the Water Projects Bill above and beyond that. And then House Bill 26-1342, negligently luring bears, passed, and that gives CPW staff the enforcement tools they need to deter mismanagement of human attractants. So basically, knowingly creating the risk of luring bears, it raised penalties for that to make that a little bit easier for wildlife managers to enforce. Quite a few other happenings in the legislature. We expect bill signings on many of our priorities coming up soon. And with that, I will pass it back to you, Madam Chair.
Thank you so much. Any questions? Comments? All right.
No
I like your
updates on
background.
all the water issues? It's all fine.
I feel like I made everybody pretty depressed last time. So I didn't want to do that again this time, but let me know if you have specific questions.
Yeah, big topic. All right. Thank you. Michael Cunningham for the division reports and the executive director's report.
Thank you, Madam Chair. Good morning, members of the board. As you can tell, I am joining virtually this month. I am in French Lick, Indiana at the moment, attending the annual Interstate Mining and Compact Commission meeting, which wraps up today, and I'll be heading back to Denver in the morning. We had a really productive week where we met with representatives from the Office of Surface Mining Reclamation and Enforcement, the EPA, as well as BLM to discuss a number of important topics that the 26 member states are facing. And I'm also excited to share that next year's annual meeting will be held in Colorado. So we're really excited to host IMCC and showcase our amazing state. And I'll certainly share more details with the board as that approaches next year. To follow on some of the updates from Deputy Executive Director Padilla, in terms of the legislative session, as the board was aware, the division was running House Bill 26-1112 concerning underground injection control and gaining primacy from the EPA. We were unfortunately not successful in advancing that bill this year, but I do want to just acknowledge all of the hard work that went into this from the division staff. Also want to thank the assistant directors within the executive director's office, which had a huge role in this bill, along with our sister agencies, Division of Water Resources and the Energy Carbon Management Commission. So there was a tremendous amount of thoughtful work that went into this. It certainly was not for nothing. We've worked through some important stakeholder issues. We'll be continuing the conversation about what the next steps might look like for UIC primacy, and I will continue to provide updates on that to the board. Let's see here. I also want to let the board know the Colorado Mining Association will be holding its annual conference. It starts today and runs through the 22nd. It'll be at the Gaylord Rockies Resort. This assembly serves as a premier forum for industry experts to address significant challenges and opportunities within the mining sector, facilitating professional networking and the exchange of strategic knowledge. The division will maintain a presence at the conference via an information booth, and we will take part in the formal awards ceremony this Friday. In collaboration with the Colorado Mining Association, the division will recognize excellence in both coal and hard rock mining operations, as well as safety awards. Our award classifications include developed or continued substantial community partnerships and advanced technology or attempted technology to improve the reclamation process. Furthermore, we will confer the Pendleton Award, which was established in the memory of Dr. James A. Pendleton, who served as a principal scientist for the division. So this is something we very much look forward to each year. It's incredibly important that we highlight and celebrate the great work that industry is doing out there. Moving on to an update for the Inactive Mine Reclamation Program. I've talked with the board a little bit about the Black Diamond Coal Mine Fire Project, which is located outside of Meeker. That project is underway and is expected to continue through July. Last week on the 13th, Tara Toffey, the Senior Environmental Protection Specialist and Project Lead, gave a community presentation in the town of Meeker where we answered questions, and it was well received by the community. And following that, we also had an interview with CBS Channel 4, where we provided updates on this project, along with updates on the South Canyon coal mine fire located outside of Glenwood Springs. As a reminder for the board, this work is made possible through the funds that we receive through the Infrastructure Investment and Jobs Act. So we're doing some very important work in Colorado with those funds. And I'll continue to provide updates as we move through the summer. Additionally, the Inactive Mine Reclamation Program participated in 2 outreach initiatives last week. On May 12th, staff attended the 4th grade Natural Resource Festival in Montrose, an event organized by the Shavano Conservation District. Our contribution included an educational presentation regarding Colorado's mining history, the division's primary functions, and then critical safety protocols around abandoned mine features. Following that presentation, students were able to participate in a practical workshop where they practiced their skills at silver panning and were permitted to retain the minerals they recovered. So always a big hit with the students. Following that, on the 13th, these activities were replicated at the Wingate Elementary School for their 4th grade students as part of the institution's Colorado History Week curriculum. So really pleased to get out there. We always enjoy interacting with students. And then lastly for the board, I have a few personnel updates. We have completed our interviews for the new GIS coordinator position, and we're working through the job offer process. So I hope to introduce you to our new hire at the next board meeting. We're also currently working to fill a vacant environmental protection specialist position within the Active Mines program. We received 58 applications, which is pretty phenomenal and is a significant increase over the number of applications we had been receiving for similar positions in recent years. So we have some great candidates. Interviews for this position will be scheduled in the near future, and I will continue to provide updates on that. And lastly, we filled an accounting tech position on our finance team. Ramel Hasu is joining us from Intuit. She has a background in accounting where she oversaw accounts payable, accounts receivable, and procurement. And we're incredibly excited to welcome her to our team. And with that, that concludes the division director's report. I'm happy to answer any questions from the board.
Great. Thank you so much. Any questions? Lots of good activities. Thank you. Okay, moving along. Fairly brief agenda here. The first one being the consent agenda, number 4. Patrick Lundberg, do we have any comments or anything, or is that something we can just move to approve the consent agenda?
Staff's available to answer any questions for the board, but we don't have a presentation or any comments.
Okay. Does the board have any questions, or would someone like to make a motion if not?
I'll
Madam
make a
Chair.
motion.
Second.
Okay. Padilla. Any comments? Okay, all those in favor of approval of the consent agenda, please say aye.
Aye.
Those opposed, same sign. Okay, thank you. Number 4. Number 5, we already continued. Number 6 is we've got an enforcement hearing, file number M 2006-21. This is a consideration of a violation of civil penalty, cease and desist, corrective actions, permit revocation for failure to submit the 2026 annual report map fee. Jocelyn Carter.
Yes.
Okay. I just can't see the other side of the room. I can only see Russ, so I can't see the staff side of the room. Is there anyone, an operator, or anyone that we need to swear in as well?
No, there is not, Madam Chair.
Okay, now I can see. Thank you. That's helpful. Okay, sounds good. Take it away.
Actually, for this item, we were having issues contacting the operator, but he did reach out earlier this week, so we're requesting that we continue this item to the June hearing.
Okay. Any other information or questions from the board about continuing number 6 to the June hearing? No? Would anyone like to make a motion?
I'll make a motion to continue this hearing, file number M-2006-021 to our next meeting in June.
Okay.
I'll second that.
Second.
Lauren, thank you. Okay, all those in favor, please signify by saying aye.
Aye.
Those opposed, same sign. Okay, hearing none, we will move this one over to the June hearing. Appreciate that, and I'm glad you were able to get a hold of the operator. We have file number 7. This is an enforcement hearing. It was continued from last month. It's file number P 2009-22. This is the Golden Age number 2 mining company. Similar, but cease and desist, corrective, permit revocation, finding of financial warranty subject to forfeiture for failure to maintain legal right to enter, and to post the financial warranty within 60 days of the notice of adjustment. Patrick Lenberg and possibly other staff members. We'll just wait for a minute and see who we need to swear in for this discussion. So we have division staff.
Yeah, this is Jared Ebert. I'm with the Division of Reclamation, Mining and Safety.
Okay.
Patrick Lindbergh with the Division of Reclamation, Mining and Safety.
Thank you.
Jeff, you get here on behalf of the division?
Fugate, great. And do we have the operator present as well?
Yes, I believe she's on the phone. Miss
Okay.
Lindbergh.
She looks like she's muted.
Can you hear me?
Yep, we can hear you now. Ms. Lundberg.
Okay, fine. Yes,
Wait,
two
we're
emails.
We're just doing introductions real quick. Sorry, this is a little trickier where I got to be able to get back to you. Okay, so we've got the division and we've got one operator on the phone, right?
Correct. However, my counsel emailed in to me this morning requesting that it be continued for 2 months. No counsel from the,
So Ms. Lundberg, remember last month, what we need to do is we need to swear everyone in first, and I am the chair. So I'm going to direct the conversation of this meeting, okay? So everyone who is part of this swears to tell the truth?
yes,
Yes.
Yes, okay, thank you. And then following process, what we're going to do is we're going to allow Patrick Lenberg, because this is the name that's on the agenda here for going through this, to let us know what we need to do. And it looks like Jared Ebert also has a presentation up. So we are going to follow their order, and you'll have time to, listen to what they have to say and move along here.
excuse me, may I just ask a question? There was
Sure.
a request for continuance because I have finally found counsel. We have not yet signed an agreement. It's Kristen Thal Peters from WBD.
I hear
She
you.
Did you hear me?
I can hear you. And what I'm asking you to do is please allow the standard process that we follow for every single hearing to go along. Right now, what we always do, no matter what the hearing is, we hear from division staff. Division staff lets us know what's going on. Then we hear from the operator. So we're going to do the same thing we do for every agenda item. And we're going to allow the division to speak for one moment, and you will have an opportunity as well. Okay?
Well, actually, I'm concerned because it looks like you're going ahead without a continuance.
And I understand that that was your concern last month, and hopefully you remember that you were concerned we were going to continue, or you're concerned we were going to go along without allowing you to continue. We didn't do that. So please just let me follow the process. We have a slide up here on the screen that I'm following along with, and we're going to let Jared Ebert and the division staff just begin with their presentation, okay? Sound good?
I'll go along in protest because it needs to be continued for me to have council present.
Okay.
Madam Chair, Jeff Fugate, attorney for the division. I'll go ahead and start just a quick introduction to kind of set the table for what's being considered today. This is a very simple, straightforward enforcement matter related to a failure to submit a surety increase or a bond increase, as well as failure to provide proof that Ms. Lemberg has right of entry to the surface estate of her NOI application. Before we go into our formal presentation, which Jared and Patrick will present, Ms. Lemberg has been submitting numerous emails requesting continuous extensions based on a variety of reasons. It was just late last night or early this morning that we became aware that she has been in touch with a law firm that may or may not be representing her in this matter. I have not heard from any attorneys representing Ms. Lemberg. This is one of a series of emails where she has tried to retain counsel, and that has not gone through. At this point in time, I see no reason to continue this matter. Obviously, if she retains an attorney, the division does not object to a continuance to allow that attorney to bring themselves up to speed on this matter, but we have no indication that any attorney has been retained or will be retained. So it's our request that this matter proceed.
I protest this. He is falsifying the facts. Falsifying the facts.
That's the division's position as far as where we are at with a continuance request. Obviously, I'll hear from Ms. Lemberg if she's got additional facts, but at this point in time, we've got no reason to believe that she has hired an attorney.
There is plenty of reason to believe. And you got an email this morning that I copied you in on from my proposed counsel who just flew in from being in Los Angeles. She said that she or her colleagues in Colorado could not be present for the hearing. And she asked for a continuance. So what he is saying is outright falsification and lies. He got that email.
I can submit the email and I can read the email into the record. Again, it's a fairly simple email stating that they're not able to appear at the hearing today. They're informing or requesting that Ms. Lemberg ask for continuance, but nothing in this email indicates that they are retained, have been retained. We'll be working with her. As I said, I've not heard from this attorney. They've entered no entry of appearance here. Typically, the process is if somebody does retain an attorney, they reach out to counsel for the division and request the extension, indicating they are taking the case. That has not happened here. Understanding it looks like this just came together late last night or early this morning. That's what the division's aware of at this point in time. We've got very limited information as to whether or not Ms. Lemberg has in fact retained an attorney.
Okay. So the division staff suggests that in the sense that there has not been a formal request for continuance either by Ms. Lemberg or her attorney that has not been formally retained.
There has been a formal request for continuance. I did it through email to the division several times, and I was told that they received it. Your attorney, Mr. Woolsey, and Jeff Fugate were copied in, as well as Camille. So Jeff Fugate is not telling the truth?
She has submitted, Madam Chair, my apologies, Jeff, you get it again for the division. She has submitted numerous requests for continuances by email to Mr. Coyman, myself, Ms. Mohar. Those have been forwarded to the board for consideration. As I stated, there's a variety of reasons for the continuous request. Most of them are based on she's had insufficient time to access her file, or she's been trying to retain an attorney.
Excuse me, let me interrupt again. He finally gave me my file on May 8th when everything was due on May 10th. I pleaded with Fugit to give me the file. He finally got it to me on May 8th. This is unacceptable misconduct. I am completely up to speed. I have the right to counsel. He continues to tell falsifications of the facts and take them out of context to try and bulldoze me. And this is unacceptable.
So what I'm looking at here is, you know, this is a fairly straightforward set of fairly administrative issues that are before the board at this point. You know, I think considering, you know, that the division staff has, you know, a presentation open here. I'm not sure what new information there would be from continuing this. We've got kind of
There would be a lot of new information, ma'am. There is a lot of information that needs to come forth, a lot of legal strategy that needs to come forth to preserve my rights to mine. It is completely conclusive that I had rights, and the mineral rights are in my name, and I put that in. I put that in to the mining company's name. I was given that permission by the bank.
So
By John
again,
Lobus. That will be in front of you. All of that will be in front of you. Also, the division has received the deeds proving the severance of the mineral estate.
Ms. Lemberg.
They are completely out of line.
Ms. Lemberg.
Also, Mr. Lenberg, let me just finish my sentence, decided that he was going to manufacture a budget with hiring outside operators and engineers to do the sampling on the Blue Bowl. So that's completely out of sorts. It's not done, and it's a violation of my rights as a mining operator.
Okay.
There's plenty to go forth. And they did see this morning that there was an apology on the part of Kristen and her colleagues that they could not be present to get a continuance so that they could adequately defend the substantive issues that are in front of you concerning my mineral rights. Thank you.
Okay. So we are going to proceed with this enforcement hearing for file number P 2009-022. This is Boulder County. It's a notice of intent to conduct prospecting, otherwise known as an NOI, Hard Rock Golden Age number 2 mining. This is a consideration of a possible violation, civil penalty, cease and desist order, corrective action, permit revocation, and finding the financial warranty subject to forfeiture for failure to maintain legal right to enter and for failure to post the increase in financial warranty within 60 days of the date of the notice of the adjustment. We're going to proceed with this presentation. I do not expect to be interrupted until the division is finished with this presentation, at which point, just like in every other enforcement hearing, we will have an opportunity to hear from the operator. For the interest of time, Mr. Ebert, approximately how long is your presentation?
About 15 minutes.
About 15 minutes. Okay, so it's 9:30. We got about 15 minutes. That will leave us about maybe 10 minutes for any other information coming from the operator and about 5 minutes for some deliberation. Does that sound like a adequate schedule?
It's not adequate for me.
Okay.
All right. Again, good
I
morning.
protest.
Good morning, members of the board and Madam Chair. This is Jared Ebert with the division. I will be representing staff in this matter. As you indicated, this is regarding the Golden Age number 2 NOI file number P 2009-002 operated by the Golden Age number 2 mining company. Again, this is an enforcement hearing for the consideration of a possible violation, cease and desist order, corrective actions, and civil penalties for failure to post the additional required financial warranty within 60 days of notice of the adjustment and failure to maintain legal right to enter. The site is located in Boulder County, approximately 6 miles west of the city of Boulder. Again, this is a prospecting NOI. It proposed to affect about 0.1 acres of land in search of metals, and the surface ownership is private. The post-mine land use is rangeland, and the financial warranty currently is $200, which the division has found to be inadequate. And we have since issued a surety increase revision, and I will get into more details of that here in the coming slides. Here is a aerial photo of the area. The prospecting operation is located off North Gulch Road. Give the board a little idea. This was the map that was originally provided with the NOI applications, pretty simplistic in nature. And here is a screenshot of the operations plan that was provided with that NOI. It's a pretty simple operation that was proposed to affect about 4,000 square feet of area to dig a trench for sampling. The trench was proposed to be 35 feet long, 1 foot wide, and about 2 feet deep. Some other features that were noted at the site was a pre-existing mine shaft and a 4,000 metric ton dump. Now, there's obviously been a lot of back and forth with this NOI, and so the division felt it was appropriate to provide a little bit more detailed chronology of the file, just so the board is aware of the various facts that may come up during this hearing. The original NOI application was sent to the division on February 11th, 2009. It was then subsequently approved on June 2nd of 2009. On July 9th, 2012, the prospector notified the division in the annual report the prospecting activities had been undertaken in June of that year. The prospector also in that report explained that 4,000 tons of material had been allegedly stolen from the property in August of 2011, and that theft had been reported to the authorities. In the report, the prospector informed the division they were planning on running a drip from the Blue Bowl to the Golden Age mine shaft. In 2013, the division, in February, of 2013, the division notified the prospector that the proposed activities that was mentioned in the 2012 annual report would require a modification of the NOI and likely a required financial warranty increase. On July 1st, 2013, the prospector submits the annual report stating that the alleged theft of stockpile material had been investigated by state and federal authorities. Similar to the situation we are considering today occurred in 2014. On June 10th of 2014, the division issued an inspection report along with with a notice of surety increase, SI1. In September of 2014, the division issued a reason to believe letter for failure to post the increased financial warranty within 60 days pursuant to Hard Rock Rule 4.2.1 per 2 and failure to submit the annual report per Rule 5.6. Subsequent to that, the operator did file the annual report map and fee, and then on October 21st, 2014, all the enforcement actions were abated per the previous division director, Ms. Jenny Brandon's instructions after the prospector paid the annual fee. June 2016 is of note because it marks the end of the 5-year period to conduct prospecting. Pursuant to Rule 5.3.1 per G, prospecting activities must be completed within 5 years of NOI approval, and reclamation must be completed within 5 years of the completion of prospecting activities. Given that the last date of prospecting has been reported by the prospector to be June of 2011, therefore no additional prospecting activities are allowed at the site. They should have ended in 2016. Moving ahead, on October 7th, 2025, division staff Patrick Lindbergh conducted an inspection at the site. And then on November 10th, 2015, Mr. Lindbergh sent a signed inspection report along with a surety increase notice to the prospector. The surety increase notice was sent both certified mail and via email. On November 12th, 2025, the prospector acknowledged receipt of the inspection report and the notice of surety increase by email. On January 9th, 2026, the surety increase and the corrective actions documenting legal right of entry were the corrective actions from that inspection report were due. The division never received the surety increase, nor did we receive any documentation of a legal right to enter from the surface owners. So therefore, on March 12, 2026, the division sent a reason to believe a violation exists and notice of hearing letter by certified mail. On the next day, on March 13th, the division sent a reason to believe the violation exists and notice of hearing letter via email, and that receipt was later acknowledged by the prospector later that day. This hearing was originally scheduled for the April 15, 2016 or 2026 board hearing, and at that time, the board granted a continuance of this matter to today, and that is where we are.
Thank you.
Yeah. So the reasons for the violation, pursuant to Colorado Revised Statute 3432-113.4 and Rule 4.2.1.2 and 5.3.3, a prospector is required to post an additional required financial warranty within 60 days of the date of notice of the adjustment. Pursuant to Rule 5.3.3, the division requires that prospectors provide the division with a financial warranty in the amount of $2,000 per acre of land to be conserved, or such other amount as determined by the division. The surety increase, SI2, that was issued earlier at the end of last year, required that the operator increase their currently held financial warranty by $1,818 from the $200 currently held. This required surety, the total is $2,018. It includes a cost to backfill the proposed trench and revegetate the affected area, and includes the required indirect cost that the division would incur to effect reclamation at the site. It in no way is a surety increase to actually conduct the prospecting at the site. It is to reclaim the operation that was proposed in the original 2009 NOI application. The prospector acknowledged receipt of the surety increase notice, but did not post the additional required financial warranty within the required 60-day time frame. I would like the board to consider that on the prospector acknowledged receipt of the October 7th, 2025 inspection report and the surety increase notice via this November 12th, 2025 email, which is highlighted there on the screen. It's on page 76 of the board packet. Secondly, the division still does not have documentation the prospector has the legal right to enter to conduct prospecting and reclamation pursuant to Rule 5.1.2 per D per VI for the surface owners of record described in Rule 1.6.2 per 1E and I. This is based on our review of the public records available on the Boulder County Assessor's website. The parcel in question where the NOI operation was proposed was sold in October of 2010. Their records show that the parcel is not currently owned by the Golden Age No. 2 mining company. Failure to demonstrate the legal right to enter was cited as a problem in the October 7th, 2025 inspection report with a corrective action due date of January 9th, 2026. On May 12, 2026, the prospector did provide the Mineland Reclamation Board a copy of a warranty deed that was dated March 25th, 2009. So based on that information that was provided, the division again went to the Boulder County Assessor's website and confirmed that the parcel in question, which is highlighted there on the map, is currently owned by Taylor Carson et al. And it reflects that the proper surface ownership was sold on October 15th of 2010. Going a little bit further into the Boulder County Assessor's public records, we found that on June 10th, 2009, Boulder County foreclosed on the property and the Mutual of Omaha took ownership of the parcel at that time. In October of 2010, Mutual of Omaha then proceeds to sell the property to John and Carson Taylor, which appear to be the current landowners at the site, surface owners. So in summary, the division does not have documentation the prospector has the legal right to enter and to conduct prospecting and reclamation pursuant to Rule 5.1.2 per D per VI from the surface owners of record described in Rule 1.6.2 per 1 parent E per I. The prospector claims that they do own the mineral rights. The division at this time is not disputing that, nor are we affirming that that is indeed the case. We are simply stating that we do not have evidence that she has access to the surface. For recommendations, we recommend that the board find a violation of CRS 3432-113.4 and Hard Rock Rules 4.2.1.2 and 5.3.3 for failure to post additional required financial warranty within 60 days of notice of adjustment, and find the prospector in violation of Rule 5.1.2 per DI for failure to demonstrate the legal right to enter to conduct prospecting and reclamation. Further, we recommend that the board issue a cease and desist order pursuant to CRS 3432-124.2. Regarding corrective actions, we would request that the board require the prospector to submit an amendment to the current financial warranty for the total required $2,018 or a new financial warranty reflecting the increase of $1,818 within 30 days of the signed board order date, and require the prospector within 30 days of the effective date of the board's order to demonstrate the legal right to enter private land pursuant to Rule 5.1.2 per DI for the surface owners of record described in Rule 1.6.2 per 1 parent E parent I. Regarding civil penalties, pursuant to CRS 3432-124 parent 7 and Rule 3.3.2 parent 2B, a person violating any provisions of a permit issued under this article shall be subject to a civil penalty of not less than $100 per day, nor more than $1,000 per day for each day during which the violation occurs. In this matter, the board may find 96 days of violation. That is calculated from the January 9th, 2026 deadline to submit the SI and the corrective actions from the October 7th, 2025 inspection report to the originally scheduled April 15th, 2026 board hearing. This results in a civil penalty range the board could assess of $9,600 to not more than $96,000. Division recommends the board assess the minimum civil penalty of $100 per day for a total civil penalty of $9,600, with all but $500 suspended if the prospector complies with these corrective actions. Payment of the unsuspended portion of the civil penalty shall be due and payable within 30 days of the board's order effective date, unless the board specifies something separate. For corrective actions not completed by the date specified in board order, the suspended penalties shall be due and payable within 30 days of the board order deadline for completion of the corrective actions. Does the board have any questions?
Maybe for the record, before there are questions, or if there aren't any questions, again, Jeff Fugate for the division. I want to make it clear in the record that the division is not seeking to revoke this NOI. I think Ms. Lemberg has raised some concerns that the division is trying to take her NOI from her. That is not what's happening today. That is something that could happen at a future date if she fails to comply with the corrective actions. But at this point in time, the division is trying to create a path for Ms. Lemberg to bring her NOI into compliance so that she can continue to make decisions about how to manage that NOI. As Jared noted in the presentation, last activity at this site was in 2011. So she's well beyond the 5-year time period in which either activity or reclamation needed to be conducted. So she will have to make some further decisions about what she can or wants to do under that NOI. But at this point in time, the effort here is just to get her into compliance with the statutory minimum bond amount and to have her provide information to the division that she does in fact have surface access to this site.
Okay, thank you. Questions from the board at this point? Mr. Ebert, can you stop sharing your screen just so that we've got a bit better view of everyone on?
Yeah, 1 second. Sorry.
That's fine. No rush. We know how lovely that technology is at that little desk. Okay. Ms. Lemberg, Cami, if she is muted, can you unmute her so she has an opportunity to have her portion? So that was the presentation from the division. You know, we can certainly review, go back to those slides in terms of what they're looking for actions. But, you know, in plain language, essentially what they're saying is that this is a a notice of intent, right? It means you're the prospector, you're looking to see if something is valuable on this piece of land. But that does have, per the rules, an end of life in 2016, right? 5 years. We've got this ownership side of things. And you also heard from the division that, the intention of this is not necessarily to make it so that you don't have the opportunity to still be a prospector there, but we do need to get into compliance with the state regulations, with what the condition of the land is, because that is the general formation of this board. And what Colorado does really well is make sure that if you're going to prospect or operate a mine, that land leaves in, a good economic shape for the citizens of Colorado. So that's really what we're trying to do, is make sure that we've got an adequate surety increase so that were you to walk away, there is a mechanism for the state to come in and reclaim that land. That's not the ideal scenario, we realize, but we do need to get this in compliance. And this is all, following the rules that we have here in the state for how we conduct either prospecting or mining operations. Do you follow along with that?
I am very well aware of everything that you're putting forth, and I would like to correct your misunderstanding of several salient facts. One is there has been no activity up there because after the theft of $300,000 worth of ore, there was no activity by law enforcement or the local DA to prosecute the theft of the ore.
Okay, so that's not.
Wait a
within
second, excuse me,
board.
it is not within the division, but it made it very unlikely to be able to go forth from 2012 onward with any activity up there because it was not safe to proceed. So they knew that. The other thing is, after the proposed change to the, Alan Sorensen was the original head of the division that gave the permit. And it was based on a 35-foot trench on the Blue Bull to sample the high-grade vein going into the Golden Age. That has not changed. It was changed by proposal after we thought that we could do some core drilling and some other more elaborate investigations on the Blue Bull. And that was proposed for 2012. That did not take place. So the original plan for the permit is still in place. $200 covers reseeding, covering the trench with topsoil, and doing everything that's necessary. What was proposed by Lenberg's project was to bring in an engineer, to bring in a new project head, and have this elaborate trench dug and all kinds of machinery being used, pulled in and out. And he raised the proposed surety increase based on what he saw the activity to be going on, and that never took place, nor will it take place. So we're back to some very great disparities in the elaborate project that he put into play on a simple trench on the Blue Bull, which is a
Okay,
complete odds.
I
Excuse
have
me,
a
let
board
me
member who
finish.
has a question for you.
What?
I have a board member who has their hand raised with the question
Sure,
for you. Is that okay?
sure.
Thank you. I wanted to ask a clarifying question on the standardized reclamation cost estimate. This question is more directed at the MLRB staff. Does Colorado have a standardized reclamation cost that is updated annually?
Yes, the unit costs that go into our system that calculate our reclamation bonds is updated annually.
Thank you. And then is that based on the proposed action as defined in the proposal by the proponent, or is that defined by other means?
Our process is based on our action rules and the procedures of the Inactive Mines program should the site go into revocation and forfeiture. So it's a pretty simplistic cost estimate, mobilizing a small piece of equipment to basically backfill the trench and to do some seeding. It's a small area. However, we are required to hold indirect costs as well, which includes a cost the division would incur to bid out the project and then to oversee the project. And yeah, those are characterized as engineering and project costs that she is referring to. And so
But those are standardized costs. Yep.
Yes, that is correct.
Okay, thank you.
Again, to supplement Jared's answer, Jeff, you get for the division. There's also a statutory minimum $2,000 amount per acre, which at the time that this NOI was approved in 2009, I believe that $2,000 amount was divided by the minimum impact that is occurring or did occur at this site. That's simply not how the division calculates bonds in 2026. We do rely on that either statutory minimum or actual costs. As you all are aware, a $200 bond is likely one of the smallest bonds the division holds. That's not enough to even fill up a couple of trucks to mobilize to the site, let alone conduct the minimum work that is needed at this site. So that the $2,000 amount is not just based on the actual costs as calculated by the division, but also hits that statutory minimum amount.
Thank you.
I would like to also respond to this. May I?
Sure, briefly, please.
Okay. It was clearly placed in the permit that it could be reclaimed with a backhoe, with a fence post digger, and seed and shovels. So their proposed reclamation of something that hasn't even taken place is outrageous and it's outlandish. And it is absolutely unnecessary. And it's a violation of their own procedures. Nothing has taken place because of the intolerance and the lack of adequate safety to go up and work after the 2012 process. Also, there was a lot of environmental damage from the ore that was taken from the pile and put down into the watershed for Boulder County's water supply. None of that was ever looked at by the board. So they're picking and choosing what they're looking at. They have failed to actually look at the environmental damage that was done and have any kind of semblance of their concern about the state statutes that govern them in protecting the land and
Okay, well, that is what this board does, and that's what the division does, is making sure that the land is protected. Ms. Lindberg, you are frozen, at least on my screen. I hope you can continue to hear what we're saying here. I'm gonna pause for a second, make sure you didn't lose service. You might consider, if you're low on service, maybe taking your video camera off and making sure you can hear us through your audio. I'll give her a moment to make sure she's able to hear us.
Can I ask another question to the MLRB staff
Sure.
while we wait?
Yeah,
Thank
yes,
you.
please.
Have the landowners that you identified reached out to you at all as part of this ongoing action?
No, I don't think so, Patrick.
No, they have not. We have not reached out to the surface owners, and we're relying on her to demonstrate that she has an access agreement from the current landowners.
Okay, thank you.
I would like to just counter that it was the landowner that stole, knowing that they did not have the mineral rights, knowing that that was severed. They were the ones that stole the 2,000 tons of gold-bearing ore and made the road. And they did it because they didn't want to see a gold mine going forth.
Okay. Do we have any other questions? Whether we wanted to have the slides up in terms of sort of what some of the proposed violations are. Does the board have any specific questions on what division staff is proposing here?
I have a question, just going back. I think when we talked about this before, we talked about what was actually the authority of Boulder County versus our authority, and
Mhm.
the movement of the piles off, moving it by the owner or by someone. That's not really our realm. That's the County of Boulder.
Again, Jeff Hughet for the division. Yes, the board and division's jurisdiction is limited to kind of the NOI boundary or permit boundary for more general application. The alleged, the ore pile and the theft or alleged theft of that ore occurred outside of the NOI boundary, so there is no MLRB or division jurisdiction there. It sounds like she did contact the appropriate law enforcement agencies who have exercised some form of prosecutorial discretion to take whatever action they deemed was appropriate. I don't know that we're really aware of done a deep dive into that because it's not something that the division would enforce. We have no kind of civil liability enforcement in that, in kind of a criminal or civil context like that.
Thanks for that. Ms. Padilla?
Yes, thank you. In plain language, what is the decision point for the board? I don't know if you bring a slide back up or let me know the page in the packet. That would be helpful.
We'll pull up the slide with the staff recommendations.
More board questions? Hopefully I can see everyone. Yeah, go ahead.
Thank you. I have one final question. So regardless of the actions that are voted upon today, or whatnot, would the prospector need to apply for a new notice if additional activities or activities related to actual mining, excavating, prospecting were to occur, since this one has in all essence run its course time-wise?
That is correct. Yes, they either file a new NOI or if you can file a modification of the existing one. It's basically the same process.
Okay, great.
And that's based on the sense that in reality, 2016 was the end of that 5-year period.
That is correct.
Okay.
I have something to say about that. There is also a process by which, and this is in one of the reports by Lenenberg, that a request can be made, a reasonable request can be made to extend the time of the permit. And instead of talking to me about the difficulties of moving forward with a hostile surface landowner that didn't want to see any operative work being done on the mine and local law enforcement failing to preserve the safety of me and my colleagues up on the land, and there had been a considerable amount of intolerance in the past up there. That was never done. Instead, it's kind of just slamming me with huge fines, which I hope you find absolutely horrific because they are, and denigrating my rights under Colorado mining law. I have rights as a mineral estate owner to access the surface rights as necessary within reason to secure the minerals. That is Colorado mining law. And
Right.
there's,
Did
so
you,
basically I am in no conflict with law. or my rights, and I am being bulldozed to pay a much larger fee for something that has not yet taken place.
Okay. So did you file an extension for the NOI in 2016?
I didn't, because I
Okay.
didn't know that it was actually necessary to do that. I had been granted a continuation of the NOI by filing my papers every year, trying to figure out what to do, how to go forward. I did file some documents that secured my rights to make sure that I had legal rights to go after the new surface owners should they attempt to do something like that again, and to compensate me for the loss of over $300,000 worth of funds. I didn't, it was an impossible situation. I went to San Francisco in 2015. I kept up everything on the permit. I have been trying to figure out a good way forward. And suddenly I'm being bamboozled with an increase in a surety bond, which is not necessary. And even though there is a deed on record that shows the severance of the mineral rights, which were granted to me by the bank, one of the bank attorneys, John Lobus.
Okay, we can't go into like every single detail here.
I
We need to-
understand, but it's important that you understand some background. I'm not asking, I just need for you to understand some background.
Yeah.
There was a bankruptcy
Right.
and the stay was lifted despite industry professionals showing that there was between $300,000 and $600,000 worth of funds coming out of the dump.
I hear
And the
you on
state-
that one. And so that's where this, if you look at kind of piece by piece what's happening with some of these violations, one of the things is that there's failure to maintain legal right to enter, right?
There
So
is
that's
legal right to enter. I have a deed. It was granted to me by the bank.
okay. So
The
in
fact
process,
that
what happens, and what we heard here too as well, even if all of these things that are proposed by the board go forward, you still, there's still reclamation that needs to happen. You can still move forward with, saying, hey, yes, I do have legal right to enter. All of those things can,
but you should
move
not
within reason.
do things that are unlawful. You should not allow the board to slam all these fines upon me and try to state that I don't have rights, which in fact I do. I think
We are-
you need to throw these out and not approve them.
We're following state statute, which is across the board, whether it's for an NOI or a giant mine. There are
You are
things
not following the statute. You're violating the statute because the board is violating the statute.
I'm reading the statutes that are
I'm
listed.
sorry, not the board. Your division is violating the statute
Okay.
by what they're proposing for me to have to do.
Okay.
It
Do we
is
have
the
any-
interpretation of the statute that's at question here, and I think it's reasonable for you to throw them both out.
Do we have other questions or discussion from the board?
I am not done with my presentation.
Well, we agreed at the beginning of this conversation that we were going to do about 15 minutes, 10 minutes, and 5 minutes for deliberation. So you have, in general discussion, we were at about closing in on 20 from the prospector.
Pardon me?
We've had some discussion from you for about 20 minutes so far.
This is outrageous. I'm sorry. I need more than 5 minutes of time or 10 minutes of time. You need to have background, you need to have understanding, and you don't. And you are not following the statute. You're in violation of the statute. You're going along with things that are patently unlawful. I do have rights to access. I do have rights to be there. I do have rights of ingress. I have
So-
that because I own the mineral rights, so that needs to be thrown out. And the fact that they have concocted an increased
I'm gonna cut you off
bond,
right there because I
an
really don't
increased bond based
understand
on
about
something that has not taken place is outrageous.
Okay, I'm going to ask Mr. Fugate for one clarifying question. And then Ms. Tarrant, just 1 second, I'll get to you. Mr. Fugate, again, can you reiterate to the board and to the prospector, should all or some, whichever thing happens with the board, go through, does the prospector still have an opportunity, should she have the opportunity to show, legal right to enter or any of these elements
I
here?
will sue if it goes through.
I'm
I will
asking,
take it to court.
I'm asking our attorney a question so that we're all on the same page. Did you hear all of that? I'm not sure, you got interrupted there.
Yes, Jeff, you get it again on behalf of the division. Yeah, under the requested corrective actions from the division, she will have time to comply with the corrective actions. As we're requesting, it's 30 days from the board order that should provide the increased financial warranty and proof that she has legal access to the surface. In reality, it's going to take 15 to 30 days for that board order to be issued. So likely she'll have 45 to 60 days to comply with the board order. If it's clear to the division she's making good faith efforts to post the increased bond or prove up her right of entry, she could request an extension of those corrective action deadlines. But at this point in time, it'll be 45 to 60 days to comply with these corrective actions.
Okay, and then when it comes through as a board order as well, she's going to receive sort of these step-by-step, hey, here's one thing we're looking at, something we're looking at, there might actually be a bit more clarity that comes out in terms of a path forward for her.
Exactly. And again, I mean, division staff has provided her with information in regards to both of these requests. Staff will continue to work with her and help to the extent that she is willing to accept such help. If she does retain counsel and they want to assist with this, we will work with them to try to find a way for her to achieve compliance. The biggest thing is, at this point in time, the 2009 deed that she has provided to prove up legal right of entry, it seems to be that deed is no longer controlling on the property because of the documents that division staff presented today through Boulder County. There was a foreclosure and sale of that surface estate in 2010. And so we need something more from Ms. Lemberg to prove up since that foreclosure and sale that she somehow secures or resecures right of entry to the surface. And that could be a lease agreement. It could be a signed agreement with those surface owners. It doesn't have to be a deed or a lease. There are lesser ways to prove that up. But at this point in time, the division simply has no information that she has right of access to the surface estate.
Excuse me, I just need to correct you. When they bought the property, they bought it without the mineral rights. The mineral rights had been severed. They bought only the surface rights. So you're not giving the facts to the board as they actually are.
So again, that's why I was asking those questions. Those are opportunities you'll have when you're starting to correct these actions, which is essentially why we call this a corrective action opportunity. Does anyone on the board have specific questions from the prospector or the division staff? If so, let's have them now, and then I'm going to close testimony. You just come off mute if you have a question for either the prospector or division staff. Okay, I'm not seeing any. At this time, we are going to close testimony and have some, board deliberations. So that just means that the board, can discuss what's in front of us in terms of several of the recommendations. If this, for those of you online, there's also in a presentation file in an attached PDF is a little bit easier to read, or we can go back and forth on the slides if you've got any specific items of discussion. There's some things we might want to consider is There's some ranges of penalties, just based on a per day violation for a certain amount of times, specifically a recommended amount of, the $100 per day violation for 96 days. That would be a total of 9,600 with all but 500 suspended. We can discuss that item. Some other recommendations. Does the board have anything that you feel like is not in the staff recommendations, or would differ from the staff recommendations that you want to have a discussion about?
I have a question, point of clarification.
Yes.
If the staff, so say for example, this is addressed by the prospector by submitting an amendment or request for amendment of the notice that updates the proposed actions and activities on the site. It's my understanding from statute, and I would like your opinion on this, but it's my understanding that regardless of the activities that are proposed, statutory requirement is a minimum of $2,000 for reclamation surety. So that number really would not change. Is that correct?
Correct. I mean, I guess based on the fact
It's
that
per acre. Per acre.
Ms. Lemberg, we closed testimony. So
Yeah, but
right now,
sorry.
So,
that-
and I guess to that point, but it's a roundup. When dealing with standardized reclamation cost estimates, it's generally a rounded up to the acre minimum. Please correct me if I'm misspeaking or out of turn, MLRB staff.
You're correct.
Thank you.
Thank you. Would it be helpful? Do we want to just kind of go through each one and have a quick discussion, or if there's not a lot of question or difference between kind of what the staff recommendations are, we can have a motion, we can have a second, we can make a bit of an adjustment if needed during discussion. Not a whole lot, but. Would anyone on the board like to entertain a motion?
I'd like to entertain a motion to accept the staff recommendations as set
Okay.
forth in page 20, and I believe also on 21.
I think we will need, process-wise, I'm trying to think, just because we've got a recommended amount. I think the only variable in the recommended amount has to do with the civil penalties of recommending that there's an assessment of the amount of $100 per day, which would be a total civil penalty of $9,600 with all but 500 suspended if the correction actions cited are completed within the required deadlines. That's the board action that you are putting forth.
That's correct. Thank you for clarifying that.
Yep.
It says the civil penalty of $100 per day with all but 500 suspended.
Do we have a second?
I second that.
Okay. Any discussion? Okay. All those in favor, please signify by saying aye.
Aye.
I
Those opposed, same sign. Okay, hearing none, file number P 2009-022 passes. This is an enforcement hearing per the staff recommendations and corrective actions and civil penalties. So that will become a board order, and we will move forward. I appreciate the division's background and information on this, and also, the opportunity to continue this from last month so that we have a bit more information there. Okay.
Thank you.
Thank you.
Thank you. We have, let's see, number 8 is there's a consideration of an approval of a new permit form for the 110R reclamation only permit. Mr. Means and Mr. Russell, got about a 30-minute presentation here. Is everyone doing okay on time? Do we need a 5-minute break? Okay. No one's squirming. All right.
Yes. Just put everything right here.
Okay.
Minimize this, tag it to the desktop.
Okay.
And open it up and share.
Okay.
And then when you go to share it, you want to hit screen 1.
Okay.
I know it's.
No, you're good. Good morning, members of the board. While Elliot's getting us a couple things pulled up here, I'll do a brief introduction in that. Part of our rulemaking process and stuff was to approve a new permit, the 110R, as you're fully aware, along with some other changes and stuff that in our notice processes and everything else. So part of the act of the rule says that all of our forms have to be approved by the board. So today we're going to ask you to approve the 110R permit application. Today we're going to be presenting to you the hard copy, if you will, and stuff of this application. And there'll be some minor modifications and stuff in that when we do the e-permitting part, and we'll kind of run over that. So, but we'll go ahead and pull this up. Are you about ready?
Yeah, I'm trying to snag this.
Okay. So, but it's a formality that we go through, and at the end and stuff, we'll ask you and stuff to approve the form and also give us some deference and stuff for minor edits and stuff going through the e-permitting process. So.
Okay.
Yeah.
Yeah, it's right. It's right there at the corner. Up, that little arrow. Yeah, there.
All right, trying to hit a pinpoint picture.
Seriously.
Screen 1.
Screen 1. Yep, your screen. Okay. No, that's not.
There we go.
There.
Amazing. All right, very good. So with that, we'll go ahead and get started here. Again, today we're here and stuff asking for approval of a form. The revised Hard Rock rules approved, as I noted and stuff, and that went into effect on April 14th of 2026. That created this permit. And what we have for you today is a fillable PDF hard copy form draft that will help guide applicants through that permit process and stuff for the new application. The requirements are similar to the 110-1 and also the 111-1B permit forms and stuff that we have. So we kind of use that as a template, and it'll be adapted into the e-form and e-permitting and electronic submittals and stuff. So we'll go with that. So per rule 1.4.1 and parent 3, all information submitted in an application must be accurate and complete and acknowledged as such by the signature or other certification as designed and approved by the office, by an authorized agent, or on an application form provided by the board. So what you're going to see here is in the hard copy is we still have the notary requirements, but in the e-permitting process and stuff and that, we're actually starting to move towards certified e-signatures like you do in a PDF e-filing and stuff. So you'll start to see that. So and as noted under 3432 110 parent 9, any altercation or modification of this form shall result in the voiding of a permit issued and altered or modified form subject to operator to cease and desist orders, civil penalties without permits sections and stuff there. So those are all things and stuff in that we had to take into account there.
And I was just going to pull up the PDF.
Okay, go ahead. We're going to pull up the PDF form here and have a discussion on that for you. The most important, there's some things and stuff here. We're going to start going through it, and then I'll point out some highlights and stuff that we want to make sure that the board sees and stuff there. One of the big things and stuff in this form that we're not part of some of our current older forms is hyperlinks and stuff to our website, as well as direct links and stuff to other information and stuff there. So we're going to just go through this. If there's any questions, this is kind of informal, so please reach out and just interrupt us and stuff as we go forward. So Under the current rules,
Just
they're
to
supposed to,
No,
yes?
I at least am not seeing a form on my screen. I don't know if it's just me, but I just want to make sure that
Okay.
we're sharing the right
All
one.
right, thank you, Madam Chair.
I think I'm seeing a screen
I wonder if
saver.
I have to put it up on that screen. Yeah.
Better. Got it. Thank
Okay.
you.
Is it blown up? Is it blown up enough so you can see it?
Um,
Yeah.
No.
Yeah, we'll do our best. and
That's
stuff.
better. That's
Yeah.
good.
And
Yep.
so the form is also in the board packet. I think it starts on page 184.
Yeah.
But we'll just walk through it here. The first few pages are just instructions on the application, and then it'll start with like the formal application form, which is I think the next 5 pages, and then it'll get into the exhibit requirements where we've kind of spelled out if an operator answers these questions in this fill in the blank style, they're then complying with the exhibit requirements of Rule 6.6. So like these applicants don't have to necessarily refer to the rules to understand, are they complying with every single section within Rule 6.6?
Yeah, we're trying to make it as easy as possible. The most important thing is go back down.
Oh, yeah.
And the most important aspects and stuff of the 110R, of course, and stuff is that this is for legacy mine waste piles only. That's kind of scoop and go, as we've noted, 5 acres or less, and all activities have to be done and reclamation and stuff completed and stuff in a short time frame. And the most important parts of stuff of that is we make it very clear that this does not apply to response actions subject to or required by CERCLA or other agencies and that. And we have in here and stuff, we do have notifications to the EPA as well as CDPHE and stuff that we'll touch on here shortly. So, all right, go ahead.
Yeah, for sure. And I can kind of help guide the board on kind of the format of our standard application form. Again, these first few pages are just kind of instructions and rule citations that applicants should be aware of. This is all kind of standard, although we did work our way through this language. 2 seniors and 2 specialists kind of ensured that these instructions were kind of up to date, correct citations, you know, and we kind of adjusted the language, but it flows pretty well now.
And there, yeah, embedded in there is, like I said, links and stuff to our financial warranties and stuff. Then we get into the actual fillable form here. And the idea, like Elliot said, is to try to simplify this as much as we can so that you can fill out the form. And if you're filling it out correctly and stuff, it's eliminating a lot of the errors and other issues and stuff that we see during our normal adequacy review. So we're trying to minimize that, simplify it. I mean, there's extra information here, but on the same token and stuff, we're trying to provide that so that we don't have to go through a lengthy review process moving forward. So.
For sure. And we've linked like the applicant operator fill in the blank field here throughout the application. A lot of times in the reviews, you'll identify discrepancies of the official applicant name, which is an adequacy item. So this kind of just makes it one less item for applicants to trip up on if they forget to put periods between the LLC. Or you know, if they spell out company versus, you know, the abbreviation. So we've got linked fields throughout this form. Same thing with like the location information. The first few pages of this is like the official application form, and then it goes into the exhibits. And some of the exhibits we ask for the location information again, and just to ensure there's no discrepancies, accidental discrepancies, we've got these fields linked so then they show up later in the form. And like what Russ was saying, try to make it easier on applicants, try to decrease review time periods and all that with a number of adequacy items. And so like page 4 here would be the last of the official application form, the certification page. And then from here, it starts the exhibit A, and this will break out all the information that the permit exhibits require. an operator can work their way through this application form and just answer these questions, and then they are then therefore complying with the requirements of that rule. We've given optional templates for location maps as well as mine and reclamation plan maps, just so they've got an idea of what Rule 6.2 general map requirements require, which is legends, a north arrow, a scale. They have to be signed and dated. So rather than identifying this through the review period, an operator has, accidentally left this off. If they kind of follow the template, then they're complying with all sections of the general map requirements. And if I need to slow down at all, if we want to look through it more thoroughly, just let me know. Otherwise, I'll just try to highlight a couple of the special features within the 110R form. All good at the reclamation plan? About the seed mixes?
Yeah, the seed mix stuff.
Okay.
Probably be the next best one and stuff.
Yep. So I've got that right now. Yeah. So question 7 within the reclamation plan, Russ is going to talk about our list of recommended seed mixes, but this is within the reclamation plan. It's got a hyperlink to help identify the map as well as a KMZ file where somebody can go onto Google Earth and find the delineations of these example zones.
So yeah, and if you click on that, well, you'll see it comes up. You can go ahead and go in it. Working with our staff, with our re-veg task force, along with Brock, Bowles and stuff, our EPS3 and stuff on vegetation, we came up with some seed mixes that include pollinators, which is a big part of our rulemaking and stuff, putting that into place. And what we did is, what they did is came up with recommendations for different zones for elevations and stuff, so that an operator, a small mom and pop may not know exactly what's the best one and stuff for a meadow, coniferous, woodlands, forest kind of seed mix. Well, we've come up with a recommendation and stuff here, and they can use these, or they can, if somebody has their own and stuff, and that's great. These are we have had conversations and stuff with the soil conservation as well as Forest Service, BLM. So it's kind of a combination melding of some of those things. And certainly if we're in an area and stuff where there's another jurisdiction such as BLM or Forest Service has a more, they want to see something else and stuff involved in that, we can have those discussions and stuff too with the operator. But the idea and stuff here is to give them an idea. They can click on that, and then that gives them kind of the information they need and stuff to provide a good solid seed mix and stuff that we think will have success rates and stuff there. But we have several different zones and stuff here, all the way up through the alpine and above timber stuff there. And as we noted and stuff early, the conversations and stuff with operators, we're not trying to build golf courses and stuff here. When they remove this material, the idea and stuff is to make it better, not perfect. And that, so these seed mixes and stuff take that kind of into account, and we're looking for the best success we can have in that some of these areas and stuff, especially above alpine and stuff that are very difficult to get anything to grow. And so our hope and stuff is these recommendations and stuff help with that success. So
yeah, Russ, I was just going to ask about that, because this is different than going in with a greenfield situation and proposing seed mixes, because there's a chance that the stockpile's been sitting there for 100 years, right? So yeah, we're dealing with a little bit of a different pre-land situation.
That's true. Yeah. And some of the things and stuff in our first couple of applications and stuff that we're going to be, mindful of that. We're going to be working through some things. It may be that, some of these stockpiles and stuff may have been there for so long, they've leached through and stuff to the underground, underlying material, which may create some conditions and stuff that we need to do some soil amendments or something like that to help create a better environment and stuff for our vegetation and stuff. So flexibility is going to be the key here. Like I said, we're looking for success in that, and but also by removing this and stuff, we are making things better, as I noted. So,
I just scrolled up a little bit where it gets into the discussion of replacement of topsoil, if they did salvage any, or if it sites that lack adequate topsoil, growth media, alternatives, all that kind of stuff. So we do flush that out through the 110R. We all went through the rulemaking process pretty thoroughly with CMA and other stakeholders to talk about those alternative situations.
I was just gonna say, it seems like it would be good to put in there somewhere, just consult with the local ag extension office, because I think of them as one of the best to know locally what seeds work and don't.
Yeah, that's our normal process. They do get noticed in
Okay.
that. So in that, certainly if they come back with something that can be incorporated in that, and that's what we normally do, is we'll take a look at that and try to incorporate that in along with other suggestions and stuff that we have.
Yeah, operators are required to give them a pre-permit notice, the conservation district, as well as the county, and then the 110R we'll talk about the EPA and CPHE. But the conservation districts get a pre-permit notice, and then they'll get notified by us as well. And then throughout the exhibits and in this application form, there are references about reaching out to the conservation district to understand a local seed mix that, although there's these 6 examples that we put together with the Veg Task Force and the IMP program, maybe there's a better or more well suited
For that specific area.
sure. And these seed mixes here, it's pretty slick. So these seed mixes, we couldn't put it in the application form just because like printing, lots of color and the resolution, but there is a map of the state of Colorado, and they've identified the boundaries of all these zones. And it's pretty specific, where it's not just like a regional, like these 3 counties is one zone. It's based on elevation, and that's why I think the KMZ or the KML file for Google Earth is really helpful to applicants, so they could pinpoint exactly where that legacy stockpile is and kind of see what the preferred zone seed mix is. But yeah, throughout the application, we do reference communicating with the conservation district to achieve recommendations or information on soils. We refer them to, NRCS with the web soil survey. To kind of assist with maps, we've also made this checklist of what needs to be on a mine plan map and a reclamation plan map. There is quite a bit of detail here, so potentially a couple maps are required to identify everything that the rules require, but a lot of the times you'll get simplistic maps. I think we just saw that in the previous in the matter, and so now it's kind of spelled out. You kind of check these boxes going down, ensure these are on your map. So then again, kind of streamline the review and the decision by staff if the checklist is followed. And then again with the templates to kind of help make sure that we don't just reject a map because they're missing a north arrow if everything else is there. So the template kind of helps if an operator chooses to use one.
Other permits and stuff, this is kind of an important thing and stuff. As noted, it's we're only one part of the umbrella when it comes to any kind of mining activity. So if part of Exhibit F is listing out what other permits and licenses may be required, and so there's a lengthy list of stuff here and stuff just to make sure that people are aware and stuff of what they need to have. Some of our uranium stuff and that, of course, radioactive source material licenses and stuff is part of that specific in that. And if somebody clicks on explosives or whatever, we're going to have a conversation because those are strictly prohibited and stuff under a 110R. So yeah, so and that, and also coordination and stuff with our sister agent jurisdictions and stuff with the Forest Service or BLM, the county, and those kind of things. So want to make sure everybody's noticed the stuff properly. So
for sure, and like Russ had mentioned earlier, this form was developed mainly off of the kind of the style and the formatting of the 110.1 fillable form, as well as the more recent 111.1B fillable form. We did take a look, and so like this exhibit was improved to make kind of check boxes and kind of spell these out. Previously, it was just kind of a copy paste of the regs and a big run on comma list. And so that's kind of will help basically demonstrate the importance of reaching out to these other agencies to determine if, you know, your operation requires other permits that you might not have thought of. So
These are all notices and samples and stuff of proof of filings and stuff with the county clerk and everything else that are all required by rule. And then exhibit J here, this is an important aspect in that, as the board is aware, part of our discussions and stuff under this 110R were conversations and stuff with CDPHE, hazardous materials, as well as the EPA, their Superfund surplus sites. So we have had those conversations, and this is part of the notice process, and the link and stuff that's provided and stuff down here. If you click on that link, it'll take you to our website, and we have a list of current contacts and stuff for these agencies. So they don't have to go hunt down who, what, or where, because sometimes that can go down a rabbit hole. These are contacts and stuff that we've verified with these agencies and stuff is where they want these notices to be sent, so that they'll have an opportunity and stuff to see these and flag anything or any issues and stuff for that prior to us really getting into the details of review to ensure that they have a legal right of access, especially against Superfund sites. We want to make sure and stuff that the operators and stuff like that aren't getting into a situation that's going to cause them and us grief. There are areas and stuff that the EPA would be more than happy to see removed. So that's our goal and stuff there. And the same thing with CDPHE, with their materials folks and stuff, and that is there are areas and stuff that there are covenants and other things, land restrictions and stuff on that we need to be mindful of, and that so that we're not approving something that is going to cause damage and stuff to work that's already been done there. And we also, like I said, this is kind of a protection and stuff for the applicants and stuff, so they're not getting into something and stuff that's way beyond what their scope of work and stuff is going to be. So.
And so we've provided this little checklist again, and then right below it is our example or our board approved templates for these notices. So they'll fill this out, attach this to at least the first 4 pages of the application, that kind of main application form. And then this would be a pre-permit notice that gets mailed to that agency. It includes their contact information and the legal description. So then those agencies can provide appropriate feedback if needed.
That's pretty much it.
Yep. We also have, so obviously with the 110R, Exhibit K is kind of the more of the special one for this permit type, which is identification of the receiving facility. And then there's just additional templates like the on-site notice sign. Since it is 11 by 17, we have it split in half between 2 8.5, 11 by 8.5 by 11 sheets, just to provide, you know, those applicants easier assistance if they didn't want to create their own sign on a larger sign, or you know, print something out and staple it to wood, that they could at least use the application form template that we provided, as well as the affidavit here. And then the very back end is the newspaper notice, but that doesn't go out until after the divisions consider the application filed. So this is just so they have it and they're able to get the newspaper notice published as soon as we tell them to start that process. So that is the 110R form. If there's any questions, or if I should go back, we can look at a section a little more closely if needed. Otherwise, we can kind of continue to our staff recommendations.
Any questions?
Questions?
All right. You're right.
I have a silly question. That big 11 by 17 notice, does that pre-populate based on the information, or do I have to figure out how to type sideways?
No, it does. And it also, when you click on it, it does have kind of standard, not
sideways text, but it does also pre-populate where the applicant name gets transferred as well as some of those other details in there.
Any other questions or comments from the board? Well, I think it looks really great. I think it's educational, you know, particularly because some of these operators may not necessarily be formal miners, right? This might be the first time they're sort of encountering some of this. So I think that the links and making it as easy as possible, you know, to find the information is really great.
Great. Well, thank you, Madam Chair. So staff's request is that the Mine Land Board, after consideration and review, accept the 110R fillable permit application form as presented today. In addition, in line with our 2018 presentation and stuff on the 111 1B fillable forms, DRMS staff requests that the board allow minor changes to the form without the need for additional hearings, as long as those changes are minor and approved by the Minerals Program Manager. It just gives us a little bit of editorial license and stuff for that when trying to e-permitting and other things and stuff there. But anything substantial, of course, we'd always bring it back to the board. But that's our request for today.
We have a motion?
I'd like to make a motion to accept the staff request as read.
Second?
I'll second.
Any discussion? Okay, all those in favor signify by saying aye.
Aye.
Aye. Any opposed? Okay, hearing none, the form is passed. Thank you so much for that presentation. That was pretty interesting, actually, considering we were looking at a fillable PDF. I think it's fascinating. I think this is a really important initiative, and I'm glad we've been able to formalize how to go about doing this, because this is important for the state to do well. And I'm guessing, looking at Mr. Cunningham over there at his conference, I'm guessing we're on the leading edge of this in terms of having a process.
Yes, yeah. So yeah, and just for the board's information, you know, we've had a few operators and stuff reach out to us to have some initial discussions about the 110Rs. There's nobody rushing in right now and stuff waiting for this form, but there is discussions. So we're hoping and stuff here soon and stuff to have our first applications in. And as noted, staff is going to be very attentive to the first ones and stuff to see where pinch points are, to try to make this and stuff economically feasible for them, as well as returning lands to the beneficial use. So.
Yeah, great, good work. Do we have anything on item number 9? Any discussion items or 30-minute discussion?
No, ma'am. Our board form and stuff with that we figured was education enough for today.
Okay, cool. Cammie, is there anyone online here for public comment?
No, there is not.
Okay. Do we have a reason to go into executive session?
No, we do not.
Okay.
This is Chuck Hoyman. No executive session today.
Okay, thank you. And then on the last sheet of it was just a notice of a final determination of a designated mining operation, a DMO. Is there any action we need to do with this, or is this just a formalized notice?
Madam Chair, it's just a formalized notice. It's part of Rules 7 process and stuff for making that determination. So it's in the rules, it states that it has to be posted in the agenda. So we have done so.
Okay, thank you. But no board action is required.
No board action.
Okay. With that, looks like we are done with the formal agenda. Do we have a motion to adjourn?
So moved.
Stegelmeyer, second by Padilla. Thank you all so much. Thanks for the interesting presentations, and we will see you all next month.